Before the break, we were talking about a judge ruling that Trayvon Martin's school and social media records can be handed over to the lawyers defending his alleged killer. That's George Zimmerman. Let's bring in the legal guys. Avery Friedman, a civil rights attorney and law professor who joins us from Washington, and then Richard Herman, a New York criminal defense attorney and law expert who joins us from Las Vegas. Hello, gentlemen.
Hi, Marty. How are you?
Very good, thanks. All right, let's talk about this. Some interesting stuff coming out of the Zimmerman case. First and foremost, let me ask you this, Richard. The attorneys that were representing George Zimmerman want these records, social media, and they want school records. Why do they want them? It sounds like a fishing expedition.
Oh, Marty, it's not a fishing expedition. They want to show that Trayvon Martin had a propensity for violence. They want to show that and then try to argue to a jury that obviously Martin, with his propensity for violence, was the aggressor. However, before everybody goes crazy here, it's just for discovery purposes at this time. It does not mean this material will be admissible at the time of the trial. So that's for starters. And the judge will have to make that decision during the trial or just before it. But in any event, it may not come in at all, or it may come in with a sort of limiting instruction to the jury by the judge on how they should receive it.
Quickly, there was also the prosecution, they sort of said turnabout's fair play. They wanted the medical records of George Zimmerman. Yeah. The defense initially said, oh, no, that's too personal, but they eventually won. What are they looking for there?
Yeah, for what purpose would they want those, Maury? To show that Zimmerman's a mental case? I don't know. The judge is going to take those, look at them in his chambers, and make a determination on his own whether he thinks they're relevant. So that's where that's going to go. But the judge has already admonished and instructed the defense attorneys, when they get this material, this discovery, not to turn it over to the public, keep it amongst themselves. So when they get his school records, they cannot turn this over to the public. That's the ruling of the judge. Quick, one last thing. What's very telling here, Marty, is that the prosecution is taking their sweet time and turning over discovery, and the defense is ranting and raving that the district attorney is not releasing material that they have an obligation to release. I think that's
there's a hearing coming up on that too, by the way.
Yeah, there is. Yeah. All right.